Article 33 empowers the parliament to curtail the fundamental right of certain peoples who are discharging their duties with the armed forces. And therefore, whenever you talk about rights available to a man in uniform, then Article 33 comes into play, and the rights available to them are curtailed by virtue of laws made by the parliament in the backdrop of the requirement of Article 33 of the Constitution. That's one thing which I want each one of you to remember. Now, when you talk of military law जो था, जैसे हमारा आर्मी एक्ट है, सन 2011 में ब्रिटिशर्स ने बनाया, और जब ब्रिटिशर्स ने उसको बनाया तो उन्होंने पनिशमेंट, डिसिप्लिन और प्रोसीजर्स ऐसे लेट डाउन किए कि जो भी वो चाहेंगे वही होगा। और एक व्यक्ति हैं जिनका नाम है D.M. सिन्हा। He was the first Judge Advocate General of the country, and he became the Judge Advocate General when he was working in the British Army. And when India became independent, he was entrusted with the job of amending the military laws, and therefore he is the architect of the Army Act of 1950. And when he was enacting the Army Act, it came to his notice that with the nature of discipline required and the procedures to be followed in the army, there has to be something in the Constitution which empowers the parliament to make a law curtailing certain rights. And it was his brainchild that Article 33 of the Constitution came into being. He took an appointment with Dr. Ambedkar, told him about the effects of right to be curtailed, and that is how Article 33 of the Constitution came into being. And I can tell you, he became the first JAG to be appointed as a judge of the High Court, that is Guwahati High Court, and he was a judge of the Guwahati High Court for more than 8 years. So that is the founding father of the military justice system in the country, and he was the first JAG appointed in the time of the Britishers. Now, if you go through the military law consists of 3 acts: Army Act, Navy Act, Air Force Act. Now, as far as the structure of the military is concerned, when we talk of military, all the 3 are part of the military: Army, Navy, and Air Force. The Army is the biggest force, having a force of more than 13 lakh. Air Force comes next, which has about 1.25 to 1.30 lakh. And Navy is the smallest unit, with about less than 85 to 90,000 people. All the 3 have 3 different acts. Now, the acts provide for various aspects, from the time of recruitment, enrollment, attestation, what are the service conditions to be framed, who can formulate the law. But the most important aspect pertains to discipline and procedures for making discipline. I'm talking about discipline and procedure because you are all lawyers and you would be concerned with that. And that is where most of you might have heard something like court-martial, procedures for court-martial. Now, when disciplinary action is taken, it's in 2 forms. One is an administrative action, and the other is disciplinary action through trials, which are known as court-martials. Now, court-martials are of various types: general court-martial, district court-martial. I'll not go into details of all these things, but the procedure is laid down in the Army Act, Navy Act, Air Force Act for conducting the court-martial. Now, one important thing which I want to tell each one of you is that a man in uniform may commit any offense. The offense may be an offense under the Indian Penal Code. The offense may be an offense under the Prevention of Corruption Act. The offense may be one under the POSCO Act also, child abuse. The police registers a case against him. And the moment the case is registered and the investigation is over and the challan is to be filed, if you see section 125 of the Army Act, it mandates that the police should take permission from the commandant under whom the man is working, and give an option to the commandant either to permit the police to prosecute him in a normal criminal court, or the commandant would take a decision, no, give the case to me and I'll prosecute him through court-martial. And if the commandant directs for prosecution through court-martial, then the court has no other option but to give it. The only option available with the judge or the criminal court is to say that for these reasons I don't agree, and make a reference to the central government, and the central government will decide who will prosecute the matter. And in 99% of the cases, the moment a commander asks for prosecution by court-martial, the matter is handed over to him. Now comes the issue which all of you should take note of. If a person is prosecuted in a criminal court and convicted, the conviction is for the same offense. 302 IPC, 326, 327, 376, Section 7 of Prevention of Corruption Act, POSCO Act, and the sentence is also same. But here, the sentence is imposed by the court-martial. And the sentence are punishment for the criminal offense, that is imprisonment, along with an action for removing him from service or debarring him from service, demoting him or whatever it is. In a civil organization, he will be prosecuted criminally, and if he's working in the government or some establishment, the employer takes a decision. Here, both the decisions are taken based on the same procedure. Now, once he's punished, for example, he's punished for an offense under Section 302, and he's sentenced to life imprisonment, what is the remedy available to him? An ordinary person who is tried by a session court goes to the High Court under Section 389 CRPC. But an army person does not have that right. Right from 1950 up to 2009, when the Armed Forces Tribunal was created, the only remedy available to them was a petition under Article 226 of the Constitution. And as all of you know, Article 226 of the Constitution does not permit inquiry and interference or judicial review on factual aspect of the matter. And therefore, a man punished under the court-martial is deprived of his right of appeal. And therefore, in 1982, one Major Prithpal Singh Bedi filed a petition in the Supreme Court, and the Supreme Court gave a judgment in 1982 in Prithpal Singh Bedi's case, where it was said that because you took an option for trying him by court-martial, can you take away the right available to him to an appeal? He does not have a right of appeal as is available to an ordinary citizen under Section 382. Therefore, a provision for appeal should be provided for him. From 1982, the matter was pending in the parliament. It was only in 2007 that a parliamentary committee recommended, yes, there has to be a forum for appeal, and that is how a recommendation was made, as it is in many of the Western countries, to create a military tribunal to try all these things. And ultimately, based on the parliamentary committee's recommendation, the Armed Forces Tribunal Act of 2009 came into force. Now, if you see the Armed Forces Tribunal Act, you will find two sections, Section 14 and Section 15. Now, Section 14 gives a general jurisdiction to the tribunal to deal with service matters. And Section 15 is a provision which is akin to Section 389 of the CRPC, and today the Armed Forces Tribunal acts as an appellate forum under Section 389 with regard to all court-martials and punishment of by the court-martials, including suspension of sentence, grant of bail, interfering with the punishment, reducing the punishment, holding the trial to be illegal, vitiating the trial, and even remanding it back. That is the biggest development that took place in the Indian military judicial system when the Armed Forces Tribunal Act of 2009 was created. And today, we deal with such cases. These are the matters, these are some of the issues which have come. But still, the investigation under the police of criminal case under the Army Act, Navy Act, Air Force Act is done by a cumbersome procedure which is known as court of inquiry. Then there is a summary of evidence, and then the charges are framed, then it goes to the tribunal. So that procedure is cumbersome, and therefore there have been recommendations for curtailing this procedure. But another aspect of court-martial system which is subject to criticism is that there is no permanent system of court-martial. There is no permanent body or tribunal which does the court-martial. As and when a case comes, the commander constitutes a court and gives it to the court for court-martial. And the court which is created is a temporary one. Today, depending upon the rank of the officer, a major general may head the court-martial as a presiding officer. He will have 2 officers. Tomorrow, if another court-martial come, it may go. So therefore, the persons manning the court-martial are different. It's not a thing where the same person does everything and they are guided by the advice of the judge advocate. They do it. So therefore, there has been an allegation that what we call in military terms, that the court-martial is done under the command influence. Command influence means the commander, even though he creates the court-martial, he takes a decision as to what should be done, and that command influence makes the court-martial, loses the significance of independence of the court-martial. And even though in the appellate forum, we do try to remove that, but then the demand is that a permanent tribunal should be created for the purpose of trying the court-martial. There are various opinions where it says that at unit level or at command level, you should have a permanent body of persons who will be known as the court-martial tribunals, and they will do the court-martial, and they will be doing only court-martial. I can share with you an experience which I had about 2 months back. The Judge Advocate General of England came, and he was saying, Ki, you have taken the Army Act from where we left, and you are going on with that with some amendment. But we in the European countries and England have an act made in 2006, which is different from that, and we have created independent tribunals to deal with court-martial, and a judicial officer who can be appointed as a judge of the High Court heads the court-martial tribunal, and he conducts trial for all Army, Navy, and Air Force, and from his order, the appeal goes to the High Court. So in India also, there is a demand for a permanent court-martial. The government is seized of the matter, and hopefully, very soon, we will get it. So these are some of the issues which I also feel should be addressed. I have also submitted my opinion in this regard through various authorities. So these are few things which I thought I should tell you. And if I keep on going, it will take at least 2 days for me to explain many things to each one of you. But I would say one thing, that working for the people in uniform and doing something to you, something to them, gives a peace of mind to you. And therefore, if any of you are interested in coming to this field, you should try to participate in the JAG competitive examination, become a JAG officer, and experience the feeling of serving the officers. I know of many JAG officers who have entered service, worked as a JAG officer for 10 or 15 years, left it, and today are designated senior advocates, both in the Supreme Court and various High Court, with flourishing practice, and deal with normal cases also, and other cases pertaining to the armed forces also. And I find a lot of women students, lady students here, and I can tell you, every day, JAG officers who appear before me, 40 to 50% of them are women officers holding the rank of majors, lieutenant general, colonels, and brigadiers. So you will be, I suggest you can do that also. Thank you very much.
Thank you. सर, 2 चीज़ें जब आप बात कर रहे थे तो 2 चीज़ें मेरे दिमाग में आ रही थी. एक तो ये कि अगर विमेन की हम बात करें तो अब सुप्रीम कोर्ट ने भी विमेंस को लेकर, खासकर सेना में जो विमेन हैं उनको लेकर सर्विस में समान हक की एक बात कही है. क्या ये मामला भी ट्राइब्यूनल के सामने आया और उसको किस तरह से डील किया गया, क्योंकि वो एक हिस्ट्री जाननी बहुत ज़रूरी है.
ये मामला 2010 पे जाता है. 2010 तक ये था कि वुमेन को शॉर्ट सर्विस कमीशन में लिया जाता था. शॉर्ट सर्विस कमीशन होता था उस टाइम 7 साल और 3 साल का एक्सटेंशन, टोटल 10 साल. फिर वो हो गया 10 साल और 4 साल का एक्सटेंशन, 14 साल, और उसके बाद आपको वापस घर भेज दिया जाता था. आपको पेंशन भी नहीं मिलता था, कुछ नहीं मिलता था, और आपका रिक्रूटमेंट भी हर ब्रांच पे नहीं होता था, लिमिटेड ब्रांच होते थे, जैसे एजुकेशन ब्रांच है, नर्सिंग ब्रांच है, मेडिकल ब्रांच है, लॉजिस्टिक ब्रांच है, बाकी कई ऐसे ब्रांचेस थे जिसमें आपको नहीं लिया जाता था। तो जब ये हुआ तो 2010 में एक लेडी ऑफिसर थी, उसका नाम था बबीता पुनिया। शी अप्रोच द हाई कोर्ट ऑफ दिल्ली सेइंग दैट दिस इज डिस्क्रिमिनेटरी, हमको भी मिलना चाहिए। 2010 में वो केस हुआ, 2016 में दिल्ली हाई कोर्ट, 2014 या 15 में दिल्ली हाई कोर्ट ने उसमें जजमेंट दिया और कहा कि नहीं ये गलत है, लेडी ऑफिसर्स को भी परमानेंट कमीशन मिलना चाहिए। वो मैटर तब से लेके सुप्रीम कोर्ट में पेंडिंग रहा और अभी 2020 17 मार्च को जस्टिस चंद्रचूड़ की बेंच ने एनी नागराज और बबीता पुनिया के नाम से जजमेंट दिया और उसमें कहा कि वुमेन शुड बी गिवन द इक्वल राइट फॉर ट्रीटमेंट इन द army. They should be permitted to work in all the areas of the army, including combat area, so subject to their fitness and passing the required test and everything. और उसके बाद इनके होने लगे, आर्मी ने काफ़ी कुछ किया, लेकिन अल्टीमेटली सुप्रीम कोर्ट प्रिवेल्ड एंड आई कैन टेल यू that from 1st of April, women officers have taken charge even in the combat area and they have become colonels commanding a unit in the combat area. So that's a big development as far as the army is concerned. एंड मैडम का जो सवाल था कि आप भी केस डील करते हैं, हाँ हम वो केस डील करते हैं जिसमें परमानेंट कमीशन बनाने के लिए शॉर्ट सर्विस कमीशन ऑफिसर का केस सिलेक्शन बोर्ड के सामने जाता है, मेडिकल बोर्ड में जाता है और उसमें उनको शिकायत होती है कि हमारे रिकॉर्ड को ठीक से नहीं देखा गया, हमारे जो मेरिट्स हैं उसका असेसमेंट ठीक से नहीं हुआ है, हमारा जो मेडिकल असेसमेंट हुआ वो ठीक से नहीं हुआ, उसकी एडजुडिकेशन हम करते हैं। और कई केसेस ऐसे आए हैं जिसमें लगा कि हाँ इनके साथ अन्याय हुआ है, तो हमने उसको क्वैश करके उनको फिर से वापस परमानेंट कमीशन देने के लिए बोला। और कई लोग को परमानेंट कमीशन नहीं मिल सकता तो ये कहा है इनको 4 साल का एक्सटेंशन दीजिए, 4 साल और देखिए, उसके बाद इनको परमानेंट कमीशन के लिए रिकंसिडर करके डिसाइड करिए। तो हमारे पास कई वुमेन ऑफिसर्स आर्मी, नेवी, एयरफोर्स के हैं जो कि अब ये सिलेक्शन चाहते हैं। और एयरफोर्स में आज वुमेन ऑफिसर्स को फाइटर पायलट का भी पोस्ट दिया गया है। So that's a big thing, and the entire credit for this goes to the Delhi High Court because it initiated the thing with Babita Punia and ultimately to the Supreme Court for having brought it to a logical conclusion.